Now, did you note any of those specific, if you recall, if I might summarize it as being, you said leading questions, for instance, and praising or feelings types of questions? Yes. Okay, let me ask you again. You reviewed the March 1, 2007, or sorry, 2006 statement, correct? Correct. I'm going to show you what has been marked as 216. Do you recall also receiving that transcript of the March 1, 2006 video statement? Yes. As an example, I'd like you to turn to page 615. I found the page. 3 down, I guess it would be 3 names down. I think it starts Fassbender. That's a large paragraph. I see that. If you could begin reading from, again, Attorney Kratz. Judge, I'm going to, excuse me, I'd like to interpose an objection. And if we could approach, or if I could be heard outside the presence of the jury, I'd appreciate it. We can probably do it by approaching the court. All right, approach. Discussion off the record. By Attorney Freeman. I'm sorry, Doctor. Do you have before you now that same transcript? I do. Okay, you're at page 615? I am. And starting with that same line where it's Fassbender begins again, or could you read, and it's a long paragraph, I'm not going to ask you to read the whole paragraph, but if you can read through to, I believe it's the 4th sentence where it starts, I just don't see that. If you can read that, please. I'm sorry, read it out loud if you could. I had to find where I was supposed to stop. Okay, sorry. That's fine. As read. Again, or whether Blaine saw it or not, the time periods aren't adding up. They're not equaling out. We know when Teresa got there. In parentheses, Brendan nods yes. End parentheses. And I guarantee you, Teresa's not standing on a porch when you come home from school. Okay, then if you could skip down to where it says Brendan right after that paragraph, and what is the response? I got off the bus, I walked down the road, and when I got to that thing, the other house, I just sat in there for nothing. I can see her Jeep in the garage just sitting there, and I didn't see Stephen and her on the porch. The next line that starts with Wiegert, you did or you didn't. And then Brendan, I didn't. Okay, is this an example, for instance, of one of the two phenomenons, yield or shift? Yes. And what is it? It's a phenomenon, it may be leading in terms of it's likely both, and I'm sorry, you said likely both? Both. And is that possible when you're doing an evaluation under Gudjonsson, that you might have something that is a kind of a hybrid of both? On the Gudjonsson, the only measures leading to keep it pure and shift. It doesn't have the two combined, but in real life, oftentimes questions contain both. There's mild pressure as well of some sort, or mild attempts to have a shift along with combination with a leading question, and in this example, was Brendan's answer a shift? It was both. A response to leading, to yield, and to shift? Yes. Back on 615, Doctor, the same paragraph, that large paragraph where it begins Fassbender? Yes. Near the very end of that paragraph, it begins, I can tell you we don't believe. Can you read that line? As read. I can tell you we don't believe you because there's some things that are wrong, but you got to tell the truth. And again, is that factor you were discussing in consideration of yield and shift? That's in consideration of a shift. That's the interrogation factor that you were talking about? True. Let me ask you if you could skip to page 587. I'm there. And if you could go 8 lines down, starts with the person speaking it says Wiegert. Yes. If you could read from there until I ask you to stop. How many lines down? 8. It starts with Wiegert. It starts, so Steve stabs. Okay. As read. So Steve stabs her first, and then you cut her neck. Brendan, in parentheses. Brendan nods, yes, end parentheses. What else happens to her in her head? Fassbender, it's extremely, extremely important you tell us this for us to believe you. Wiegert, come on, Brendan, what else? Pause. Fassbender, we just know, you need to tell us. I'm sorry, could you read that line again? We know, we just need you to tell us. Brendan, that's all I can remember. Wiegert, all right, I'm just going to come out and ask you, who shot her in the head? Brendan, he did. Fassbender, that's fine, doctor, right there. I'm sorry. And again, at that point is, my question is essentially the same as before. Is this an example of the yield or shift that you were describing previously in the Gudjonsson suggestibility scale? Shift. And why is it shift? Because there's pressure to give a statement rather than merely elicit information. And I'm going to ask just one last example. If you could skip to page 574. Yes, sir. If you go 7 lines down, again, it starts with Officer Wiegert and it says, we know what happened. Start with that line. As read. Wiegert, we know what happened. Fassbender, it's hard to be truthful. Wiegert, we know what happened. It's okay. What did you do? Brendan, I didn't do nothing. Brendan, come on, what did you do? That's what it says. If you can go a little further, as read. Fassbender, what does Stephen make you do? Wiegert, it's not your fault. He makes you do it. Brendan, he told me to do her. And at that point again is this again an example of these lines, the officer's questions and the responses, example of the technique you were referring to in how one shifts their answers or yields? It's an example of using a theme of minimizing responsibility or culpability or seriousness of a crime and being sympathetic in an attempt to have a person answer leading questions. Okay, and that's the yield that you're describing on Gudjonsson? Yes. I won't go through any further examples, but would it be fair to state that you did review both transcripts as well as the tape and observed other examples? I certainly did. What I want to go back to is some additional factors that you considered in regards to your evaluation. Did you consider character of the defendant, his age, for instance? Yes. And what significance does this age have on your opinion that he is susceptible to suggestion? Individuals who are minors have a greater likelihood of being susceptible, especially even when they're older minors, i.e., or that is 15 or 16, they have a much higher likelihood of being susceptible, especially when that's coupled with low intellectual functioning. Does a lack of life experiences or maturity level also impact on that decision? Yes. Were you able to, do you have any opinion in regards to Brendan as far as lack of life experiences or maturity level? His life experiences are limited because of his social withdrawal and social alienation and his living within himself and within mostly relating to his family, not friends. Does one's familiarity with the police, is that a factor to consider based on the research in the Gudjonsson research in formulating an opinion on one's susceptibility to suggestion? Based on Gudjonsson research and others, yes, that's true. And was that a consideration with you when you reached your conclusions about Brendan? Yes. How so? Individuals who have minimal or no contact with no criminal history have a greater chance of, or a greater susceptibility to being suggestible. Does anxiety, is that a factor to consider in the research or in the Gudjonsson research when reaching your conclusions as to susceptibility to suggestion? Yes. And was that a factor in this case when you met with Brendan? Yes, because both state anxiety at the time of an incident, of an interview, as well as trait anxiety, whether a person has a trait of being anxious in general during their life, is correlated with increased suggestibility as well. In regards to learning disabilities, is that a factor that you would consider in reaching your conclusion? Yes. And was that a factor in this case? Brendan told me that it was a factor during the interview, and I subsequently had an opportunity to review about 2 inches worth of 2 inches of collateral data from the school system showing that he had been having substantial learning problems and special programming and individual education programs throughout his education. Or I should restate, at least that back to 4th grade, maybe earlier, and it was pointed out to me. But you only had the material back to 4th grade? I believe so. Would you consider any one of these characteristics or traits individual, away from the I guess, the context of it in its totality when making your determination whether one is susceptible to suggestion? No. Why not? It's essential to do a comprehensive evaluation to get the most accurate, valid conclusions, to let this jury know what the status is of Brendan's suggestibility, or lack thereof. And to do that, I administered a variety of tests, as do other forensic psychologists who do this type of work, to provide that information. When you reached your conclusion that you've previously stated, did you consider all of these factors? I should answer out loud. Absolutely. Is another factor to consider memory or memory deficits? It is. Now, in that regard, did you actually perform any tests on Brendan to assess his memory? No. Did you review any collateral information that might have assisted you in determining what level of or what type of memory he has? Yes. And what were those records? Records were, Attorney Kratz, Judge, excuse me, school records, Attorney Kratz. I'm going to ask that question be phrased before or after he's rendered his opinion in this case. Attorney Freeman, that's fine. Attorney Kratz, in other words, when they were reviewed, and were they included in his opinion? The court, go ahead, rephrase it. Attorney Freeman, that's fine. And my question is, did you review any records that reflected upon Brendan's memory, whether he has a deficit or not? And did you review those before or after you performed your original evaluation of Brendan? That's two questions. I reviewed documents regarding memory, but those documents were from the school and they occurred after the time that I wrote a report summarizing my findings. Did it impact, did those additional records impact on your opinion? They reinforced and were consistent with my opinion. In regard to your opinion, in case I may have forgotten to ask, are all of your opinions today in regards to Brendan within a reasonable degree of psychological certainty? Yes. Attorney Freeman, Judge, I have nothing else. The court, we'll break until 10:35. Attorney Kratz, that's fine. The court, presumably you have some cross-examination questions? Attorney Kratz, I certainly do, Judge. Recess had at 10:15 a.m., reconvened at 10:38 a.m. The court, Mr. Kratz. Attorney Kratz, thank you, Judge. Cross-examination by Attorney Kratz. Good morning, Dr. Jordan. Thank you once again for coming this morning. Good morning, my pleasure. First of all, I want to talk about your profession generally. That is the profession of psychologist. It's not unusual for psychologists, whether clinical or forensic psychologists, to appear and testify in a court proceeding. Is that correct? No, it's not unusual. Are there, however, rules of professional conduct for a practicing psychologist similar to the rules of professional conduct that lawyers have to live by? I don't know whether there's rules. There are ethical standards and principles, yet for both the American Psychological Association and as promulgated by the forensic component that I referred to of the APA. All right, and I understood, at least from a last opportunity that you and I had to talk about this case, that you are vigilant in complying with those rules. In other words, and not to put too sharp a point on it, but you pride yourself in not just giving the answer that a client wants to hear, but in giving both sides, if in fact that is what the evidence points to. Isn't that true? I try my best. Do your ethical rules, in fact, prohibit or frown upon promising what you might say in advance of being retained by a specific client? Yes. Do they frown upon a prediction or an advanced promise of what you might say in court or in a testimony kind of setting? They don't frown on saying whether the case seems like it's worthy of evaluation, but in terms of promising results in writing or at testimony, that's not proper. As an example, it's not proper to promise that you won't change your opinion or you won't change your answer as a result of what we're going to do now, which is cross-examination. That's true, isn't it? My opinion is my opinion, so it's not changing. My question is it improper within your rules of professional standards to promise or predict that you will not change your opinion after being cross-examined in court? I can't answer that yes or no. It depends. So no matter what I present to you to the contrary, or what facts that I may present to you, do you still believe that you are open to revising the opinion that you have first or during direct examination furnished to this jury? If I obtain additional research information or additional collateral data that I didn't have before, then that's true. Okay, and I